Well, welcome everyone to our webinar today. On behalf of Professor Eva Nolan and I welcome to the annual Children's Rights Lecture. And Eva and I have in common, alongside our impenetrable and apparently superfluous vowel heavy names, the privilege of leading the Children's Rights Group at Doughty Street Chambers together. And our group was founded in 2019, the year of the 30th anniversary of two landmark legal instruments, the UN Convention on the Rights of the Child and the Children Act 1989. And it was very important to us to recognise children's rights as a specific discipline and as an area where we can learn from each other across different practice areas. And as a mark of intent, our group is led by one of the leading academics in children's rights, Eva, and by me as a practitioner. And bearing that in mind, we are hugely honoured today to have as our chair for this annual lecture, Lady Hale. And Lady Hale, in one person, has combined academic expertise, judicial expertise, and in her career. And you have in front of you the brochure for today. And I believe it's also going to be put in the public chat now, which makes clear just how glittering Lady Hale's work has been in general, and in particular on children's rights. And I may say this despite my Irish background and not being a royalist. She is really children's rights royalty, and we're hugely honoured to have her here today as the chair. And we're in for a real treat today with the annual lecture, with our speakers, and with the incredible panel who Lady Hale will be introducing. But we felt we would be remiss in starting this without introducing Lady Hale herself. We're incredibly grateful to her for joining us today and for chairing this session. May I also just say that there's two quick technical points. The first is that you as members of the audience have your cameras switched off automatically and you're muted automatically. So if you want to noisily clatter your cup of tea or your glass of water while you're at the screen, we won't hear you and you won't disturb us. So please don't worry about that. And the second thing is, if you've got any questions or comments during the session, please use the public chat function and send a comment through. And we at our end will be collating the questions, and we're determined to leave enough time at the end for discussion. And we hope to put your questions to the superb speakers. So without further ado, if I can hand over to Lady Hale. Thank you.
Thank you very much indeed, Keithan, and thank you for inviting me to chair this afternoon's event. Good afternoon, everybody. It is wonderful to be with you all. There are indeed some advantages out of our present situation because it means that so many of us can join an event like this from out of London, and that dissipates some of the huge London centricity that we have become used to in recent years. And welcome to the second annual Children's Rights Lecture. And this is an example of looking beyond London centricity because it is going to be coming to us from Scotland. I am extremely interested in the subject matter of today's lecture because it is going to be delivered by Bruce Adamson, who is the Scottish Commissioner for Children and Young People, and Becky White, who is a member of the Scottish Youth Parliament. And they're going to be talking about advancing children's rights in the UK, but the focus is going to be on the plan that the Scottish Parliament now has for implementing in full the United Nations Convention on the Rights of the Child in Scottish legislation. Now, for years, we have been told by the UK government that the convention is simply not a suitable tool to be incorporated in hard law. So many of its obligations on states parties are aspirational, forward-looking, hoping that this is how things will be in due course when everybody is ready and has got the resources to implement what the convention requires. And one understands, if you read the convention, why a government might say that. But there are things that can be done to improve the implementation of the convention. throughout the UK. So I shall be absolutely fascinated to learn what is being planned in Scotland and how it is expected that it will actually work out. Of course, the Scottish Parliament also resisted doing it until quite recently, and no doubt we'll learn something about that as well. So I am looking forward to a treat of a lecture, followed by an interesting set of comments from a panel, which I will introduce to you shortly. And then there will be time for Q&A from all of you, which will be moderated by Keefin, because she can keep an eye on the chat and see what comes in. So, to introduce our speakers, you have the beautiful brochure, so you don't really need anything very much from me about them. But as I said, Bruce Adamson, who is not a child, has been the Children and Young People's Commissioner for Scotland since 2017. He is a lawyer, although that's not an essential qualification for the Children's Commissioners throughout the UK, but he has over 20 years of experience in human rights. He's been a member of the Scottish Children's Panel, so he knows how the Scottish Children's Hearing System works, and he's a former chair of the Scottish Child Law Centre and was a founding staff member of the Scottish Human Rights Commission. So he has a huge amount of experience in this area, and he knows about children, and he's happy working with children, which is an essential qualification for doing the job that he is doing. Becky White, who is aged 15, is a young people's activist. She has been a member of the Scottish Youth Parliament and also a member of the UK Youth Parliament. Now, I am a great admirer of the UK Youth Parliament, and I'm sure the Scottish Youth Parliament is no different, because my own daughter was an enthusiastic participant in that, I have to say, rather more than 20 years ago, and I'm glad to know that it is still going strong. So without more ado, can I hand over to them to deliver this year's annual Children's Rights Lecture. Over to you.
Thank you, Lady Hale, for such a warm introduction, and thank you to Doughty Street Chambers for inviting us to give the Children's Rights Group Annual Children's Rights Lecture 2020. My name is Becky White, and I'm a young advisor. I work with Bruce and his team, and I'm also a member of the Scottish Youth Parliament, and I'm really excited to be here today to talk to you about the importance of incorporation.
And my name's Bruce, and I've got the best job in the world as Children and Young People's Commissioner for Scotland. It was a role created by the Scottish Parliament to safeguard and promote the rights of all children and young people in Scotland. And children have asked me to be their brave champion for their human rights, which is a huge privilege. But the best part of the role is that I get to work with amazing young human rights defenders like Becky and my other young advisors.
This lecture gives us an opportunity, the day before World Children's Day, to celebrate incorporation and explain why it's so important to us here in Scotland. It also allows us to share what we've learned on the long road to get here. I know that many of you are powerful advocates for incorporating the UNCRC into English law. And as you'll know, and you've seen, that the UK government just this week confirmed that it has no plans to do so, as it believes that children's rights are already adequately protected by domestic law. But don't be disheartened. Just as we in Scotland look to those countries which has already incorporated the convention, we want others to be able to learn from our experiences. A few years ago, there seemed that there was little prospect of incorporation happening here in Scotland, so things can change, and things can change quickly. We also want to spend some time discussing what needs to change in practical terms for children and young people as a result of incorporation.
We've just celebrated the 75th anniversary of the United Nations, and tomorrow we celebrate the 31st anniversary of the UNCRC, but we do so in a time in the middle of a global pandemic, which has disproportionately affected children and young people, and disproportionately affect those whose rights were already most at risk: disabled children, care experienced children, and those impacted by poverty. Also at a time where Brexit is changing our domestic legal protections, and technological change is bringing challenges as well as opportunities to human rights for children. Across Europe, we're seeing an increasing level of retrogressive attacks on human rights, and we're seeing young people stand up as human rights defenders and lead climate justice, anti-racism, anti-misogyny movements, which are highlighting the failures of the current approach by adults. And so working with the international human rights mechanisms and improving our own domestic legal structures to protect the human rights of children are going to be essential in meeting those challenges.
So where are we now and how did we get here? We know that we're preaching to the choir when we say the United Nations Convention on the Rights of the Child is an important piece of legislation. There are a broad array of human rights instruments which protect the rights of children, but the UNCRC is the first legally binding international instrument to fully incorporate civil, cultural, economic, political, and social rights, as well as aspects of humanitarian law. It starts with the premise that children should grow up in a family environment of happiness, love, and understanding. An international legal document signed by every country in the world except one that talks about happiness, love, and understanding.
And it builds on the Charter of the United Nations, which recognizes the inherent dignity and the equal and inalienable rights of all members of the human family, and that those are the foundation for justice, peace, and social progress. And it breathes life into the Universal Declaration of Human Rights, which proclaimed that childhood is entitled to special care and assistance. The rights contained within the UNCRC are universal, interdependent, and interrelated, and the articles cover all aspects of children's life and explain how those in power must work together to ensure that children and young people enjoy all of their rights. It has changed the way that we view and treat children within the context of international law, and proclaims children's status as human beings with a distinct set of rights, not just passive objects of care and charity. And importantly, it requires states to take comprehensive legislative measures to ensure that rights are protected. And the Committee on the Rights of the Child has made clear that for rights to have meaningful, that there must be effective remedies to address violations.
The UK has a relatively good track record for ratifying international human rights treaties, but has been slow to give human rights direct effect in our domestic legal systems, and generally only does so in an ad hoc way. Until 2017, the Scottish Government has been opposed to full and direct incorporation, but over the last few years, there's been a significant change of direction. The Scottish Government has changed its position to engage positively with the long-running campaign from civil society bodies for the incorporation of the UNCRC, and began a separate process through the establishment of a human rights leadership group to look at the wider legal framework. The Scottish Government has now committed to taking a maximalist approach to fully and directly incorporate the United Nations Convention on the Rights of the Child into domestic law by early 2021. It is simply the most important thing that we can do to ensure that children's rights are respected, protected, and fulfilled.
The UNCRC Incorporation Scotland Bill, which was introduced to the Scottish Parliament in September, is a bright ray of sunlight in what's been a very gloomy year. And it's no exaggeration to say that it's the most important piece of legislation to come before the Scottish Parliament in the 20 years since devolution. So Scotland will be following in the footsteps of an increasing number of countries, including Norway, Finland, Iceland, and recently Sweden, which have incorporated the UNCRC into domestic law. And their experience shows that it's an important way to ensure systematic and effective legal implementation of the UNCRC at a national level. And so full and direct incorporation into Scots law is going to make rights real for children. It's a massive step forward and hopefully will set a precedent for bringing broader human rights treaties into our domestic law.
This has been a long process. After all, the convention was signed in 1989 and was ratified by the UK in 1991, but it's sped up significantly in the recent years. Some of the key milestones include the Children's Scotland Act, 1995, which for more than 20 years was our main source of child and family law and was influenced by the convention. It even included provisions echoing Article 12, requiring the courts to seek and take account of the child's views. The Human Rights Act in 1998 provides an important example of how an international human rights treaty could be brought into domestic law. We've taken a lot of learning from that process. The Scotland Act 1998, which specifically excludes the implementation of international obligations from the reservations in Schedule 5.
And the creation of the Scottish Parliament in 1999 meant the decisions were taken here rather than in Westminster. And dare I say that Holyrood perhaps is a more sympathetic environment to human rights arguments. But in any case, being smaller and more modern with things like electronic voting and supposedly family-friendly hours and time limits, it does provide for a very dynamic environment to engage with human rights discussions. And the devolution settlement ensured that the bulk of areas covered by the UNCRC are within the Scottish Parliament's legislative competence. And it's important to recognise the real power of our parliamentary committees, and the bill on incorporation is before one of our parliamentary committees at the moment, and they have a very important role within our legislature. They can also initiate their own legislation, and in fact, my office of Commissioner was created through this process, with the first Commissioner, Professor Kathleen Marshall, and myself as a fresh-faced legal officer learning at her feet, set up in 2004, which was the same year that Becky was born.
But there has been progress in other jurisdictions as well. In 2009, the Children's Rights Bill was introduced to the House of Lords. The bill was drafted by the Rights of the Child UK, ROC, coalition, and sought to incorporate the UNCRC and its optional protocols into UK law. The May 2010 general election meant that the bill could not progress beyond the first reading, but it did raise the profile of child rights and facilitate conversations on how best to protect them. The following year, in January 2011, the Welsh measure was passed at the National Assembly for Wales. It placed a duty on all Welsh ministers to have due regard to the subsistent rights and obligations within the UNCRC and its optional protocols. Also in 2011, the Scottish Government began consulting on a bill on the rights of the children and young people, which was aimed to establish a duty on Scottish ministers akin to their Welsh colleagues to have due regard. Despite there being no question in the consultation on incorporation, and in fact the Scottish Government's position at the time was initially that incorporation wasn't even possible, which they then softened to saying it was undesirable. Despite the fact they asked no question about it, when responding to the consultation, 25% of public bodies and 40% of NGOs voiced concern for full incorporation anyway, demanding that we go further. And importantly, the calls for incorporation came from children and young people too. Children who were aged 9 to 13, who were working with the Children's Parliament, demonstrated a clear understanding of the issues and expressed concerns that the due regard model might mean that children's rights were forgotten about. And there was a clear call from those children that rights have to be enforceable and not just optional. In the end, we ended up with the Children and Young People Scotland Act 2014, which only required ministers to keep under consideration whether there were any steps necessary that could better secure or further the effect of UNCRC. Not only did it fall short of incorporation, but what began as a due regard duty, which has had real benefits in Wales, it was watered down significantly. And so the campaigning continued. In 2017, the Scottish Youth Parliament campaign, Right Here, Right Now, kicked off. This campaign began after more than 76% of the 700,000 people of the young people who agreed to the Scottish Parliament's 2016-2021 manifesto agreement that the UNCRC should be fully incorporated into Scots law. A series of Scottish University Insight Institute seminars led by Together, the Scottish Alliance for Children's Rights, in 2017 brought together over 300 people to explore the CRC incorporation and implementation into Scotland. This included Children and Young People's Commissioner for Scotland, the Minister for Childcare and Early Years, members of youth councils, government officials, academia, civil society, as well as the public sector. These calls for incorporation were continued in 2017 for the Rights of the Child UK conference, which was held in Scotland and gathered delegates from all across the UK.
And so finally, in September 2018, the Scottish Government announced a commitment to incorporate the UNCRC into domestic law, albeit without a clear timetable attached. They said that these things take time and that they're very technical. So what did we do in a situation like that? We phoned a friend. In partnership with Together, we phoned a friend or two and called together an expert advisory group of international legal and human rights experts. And one of the things I love about my job is that when you call, people come, including Simon Hoffman, who's on the panel later today. And then we, well, mainly Simon, drafted a bill in a matter of weeks, which we submitted based on the experience in other countries, based on the rich history that we had. And we submitted that to Scottish ministers alongside Mikiko Otani, who's a member of the UN Committee on the Rights of the Child. That was almost exactly 2 years ago, on the 20th of November, World Children's Day 2018. Somewhat disappointedly, Scottish ministers weren't as excited as we hoped by the fact that we had solved their timing problem and done their work for them. But linked with calls from the Children's Parliament, the Youth Parliament and other children's organisations, we were able to put pressure on Scottish Government to agree in April 2019 that they would deliver their own bill to the Parliament in time for it to be passed within this session, which ends early next year. They established their own working group, including Professor Eva Nolan and many other distinguished human rights experts, and we now have a bill. And also, as we mentioned earlier, there's a parallel process, which again, Professor Nolan's involved in, on human rights leadership, which looks at a broader incorporation of rights. So it's all happening in Scotland.
So some key pieces of advice from us. This is a long-term process. As we pointed out to the Scottish Government, many of the children who responded to the consultation, aged 10, 11 and 12, on incorporation of the UNCRC in the lead up to the 2014 Act, are now over 18. They've aged out of the protection offered by the Convention while waiting for the political system to give in to the effect of their wishes. All the children that Bruce knew while he worked under the first Children's Commissioner, Kathleen Marshall, in 2004 and 2005 have also aged out. But much of the work is already done. Cultural change works in the background to our attitude change. We mentioned that the duties in the 2014 Act were watered down from the original consultation. However, on reflection, some people feel like it did serve to change culture and to make people more comfortable talking about rights and to encourage organisations to live up to them. So although the failure to incorporate at that stage was frustrating, it did pave a way for incorporation. It's possible to lose the battle, but win the war, so don't lose heart.
And the voices of children and young people have been the most passionate and the most compelling. It's important that children and young people help lead this process. And over the last few years, it's been incredible to see and hear from many thousands of children across Scotland who understand their rights and want them in law. This week, I received a video in response to a virtual school assembly that I did at a local primary school. I asked them at the end of my usual discussion, why are rights important and why do they need to be in law? The response from the children at Holy Cross Primary was a 16-minute video of poems, songs, art, and the strong and clear demand that their rights be respected. That video is going to form part of the formal submission to Parliament. Those children, the primary ones and primary twos with their drawings and songs, the primary sixes and primary sevens, some of whom wrote essays, they are part of the legislative process, which will deliver the most important piece of legislation since devolution. The role of us as adults is to empower children to understand their rights and empower them to know what incorporation means and allow them to support our calls for it. Political leadership and commitment is also crucial. Commitment to the principle from our political leaders is not enough. We have to be able to overcome the practical objections and the tendency of large organizations like governments to complicate things to the point of inertia. That sad shake of the head that we're all familiar with saying, yes, we agree in principle, but it's just not possible in practice. And that's why the role of our advisory group and the work that we've done to ensure that this bill is going to be meaningful is absolutely essential. It's really important.
So why is it so important? Incorporation places children's rights at the centre of legislation and policymaking. It gives them the status that they deserve and helps to redress the imbalance of power that otherwise exists between children and adults. Countries which have incorporated the UNCRC see a sustained change in the way that children's rights are respected by those in power. This leads to better decisions and resources being used more effectively to ensure that children and their families get what they need. Incorporation also makes those rights legally enforceable, providing greater accountability and a means of redress for rights violations. The bill signifies a massive step forward by Scotland to deliver UNCRC Article 4, which requires state parties to undertake all appropriate legislative, administrative, and other measures for implementation of the UNCRC. If the bill passes through the Scottish Parliament relatively unchanged, Scotland will become the leader among the devolved nations of the UK in terms of children's rights. and will also provide a strong signal to the rest of the world about its commitment to promote and protect children's rights.
Incorporation will benefit everybody under the age of 18, but it will most benefit those whose rights are most at risk. The UNCRC requires, if incorporated, that the government gives special attention. Well, it requires anyway, but the additional incorporation will give power to making sure that government gives special attention to disabled, care experience, and other children whose rights are most at risk, and to use all available resources to address their rights, to address poverty, to provide additional mental health support, the things that were so stretched during the pandemic. And there are huge problems in Scotland relating to adequate standard of living and other supports that are needed, unacceptably long waiting lists for mental health. And it's really important that we have legal structures that allow us to take action on economic, social, and cultural rights and be able to take those violations to courts if needed. And so, what are the significant parts of this new bill legally? The Scottish Government has committed to taking a maximalist approach to fully and directly incorporating the Convention on the Rights of the Child into domestic law. And the bill's currently before the Equality and Human Rights Committee, and the bill intends to meet that aim of taking a maximalist approach.
The UNCRC Incorporation Bill introduces a more comprehensive range of duties to which all parts of the Scottish Government will need to comply with. Firstly, the bill requires all public authorities, including Scottish ministers, courts, local authorities, and health authorities, children's hearing panels, etc., to act compatibly with the UNCRC. Secondly, Section 11 of the bill requires Scottish ministers to develop and publish a review of children's rights schemes, detailing their arrangements they are putting in place to ensure that they comply with their duties. This includes the use of impact assessment reports for decisions at a national level. The bill then further replaces the Children and Young People Scotland Act 2014 duty on Scottish public authorities to publish reports on how they are ensuring compliance with the UNCRC. The change of language from respecting under the 2014 Act to ensuring is significant and should guarantee greater attention to implementation than ever before.
And some of what's established in the bill will be very familiar, as it's broadly modelled on the Human Rights Act 1998, which brought the European Convention on Human Rights into UK law. The bill will make it unlawful for public authorities to act incompatibly with the UNCRC, making many of these rights justiciable for the first time. There'll also be the provision of substantive and legal remedies when violations occur. And this is particularly important, as we've said before, that the UN committees focused on the fact that for rights to have meaning, effective remedies must be available to redress violations. Under Section 7 of the Incorporation Bill, failure of a public authority to act or acting incompatibly with the UNCRC gives rise to a possible legal claim. And importantly, since the reforms made to standing in Scottish public law litigation, first coming from the AXA case and then in the Court Reform Scotland Act 2014, has made it clear that the sufficient interest test is the one that will be used in Scotland, which is more or less in line with the approach taken in England and Wales. And this is important to avoid the narrow application of the victim test, which has proved restrictive. And so recognizing that the test should be the floor rather than the ceiling, the bill needs to be wide enough to allow for that wide interpretation to ensure the protection of rights. The bill also introduces powers to read down legislation, to interpret it in compliance with UNCRC, to strike down legislation that was enacted prior to incorporation, and to make a declaration of incompatibility for legislation that comes after incorporation, as it's felt that this is the only thing that would be competent within the devolved settlement.
So if the Incorporation Bill passes through the Scottish Parliament with these jurisdictional capacities intact, it will represent a new era in protection and fulfilment of children's rights here in Scotland, with enforcement potentially unparalleled in the rest of the UK. Another crucial aspect of incorporation is the court enforceability. Currently, there are many barriers that children and young people face when trying to bring proceedings about protecting their rights. A key part of the Incorporation Bill is to ensure that rights can be taken to court as part of an effective remedy, such as a welcome protection that the 1 year time limit or any other legal time limit does not start until a child turns 18. Courts or tribunals will have the full range of relief or remedy, including damages, within their power as they consider just and appropriate.
And so we're also pleased that the bill creates new powers for my office, the Children and Young People's Commissioner in Scotland, to bring proceedings when children's rights have been breached, and also to intervene in relevant court actions. And this will strengthen our existing strategic litigation work and ensure that we can take legal actions in exceptional cases on behalf of all children and young people, rather than requiring individual children or families to take court action to ensure their rights are respected. There's a provision that requires for the Commissioner, us, to be notified and have an opportunity to intervene when any question of compatibility with the UNCRC arises in any proceeding before a court or tribunal, or when a court is considering strike down or a declarator of incompatibility. So it's going to change the way in which we can engage to assist the court, but also give a new power to ensure that we can take cases in the public interest. But it's important to note that challenges to court should be seen as the last resort. And what we're really looking to see is public authorities engaging proactively, ensuring their policies and processes are compatible with the UNCRC. And experiences in other countries which have incorporated the convention into domestic law suggest that it doesn't necessarily lead to a significant increase in litigation. And Professor Kirsten Sandberg, who is a former member of and former chair of the Committee on the Rights of the Child, gave a speech recently in Scotland where she highlighted the litigation experience in Norway and said that she thought that many of the cases that have come under the CRC were cases that would have been brought anyway, but they're able to be more effective following incorporation. The bill isn't perfect. We're arguing for a strengthening of the interpretation section, and we know that the Vienna Convention on the Law of Treaties requires interpretation in good faith in accordance with the ordinary meaning of legal terms, but also in the context and light of the object and purpose of the treaty. The current interpretation provision includes Optional Protocol 1 and Optional Protocol 2, as well as the preamble, but it doesn't go far enough. And so we're seeking further amendments to include additional interpretive tools, such as general comments of the committee, including observations, comparative jurisprudence, and also decisions made by the UN Committee under Optional Protocol 3, which the UK has not yet ratified. It is important that we see the CRC and human rights as living documents, that we recognise that the convention was drafted over 30 years ago, and rights have to be interpreted in the modern context, and it's important to have that within legislation. And so general comments, concluding observations, decisions under Optional Protocol 3 will all be really important. And a very good example of this, I think, is the general comment that's currently being drafted on children's rights in the digital environment, which was the theme of the European Network of Ombudsmen for Children last year. The CRC was drafted at a time before the digital age was what it was, before the internet was widely available, before social media was even really conceived of. And so it's important that we have additional interpretive tools to know how we interpret children's rights to protection, privacy, access to information and education within the digital age. We also have concerns around the definition of public authority, which copies that of the Human Rights Act, which I consider to be problematic in terms of the way that the jurisprudence relates to functions of a public nature. Just this morning, I was giving evidence to the Equality and Human Rights Committee in the Scottish Parliament, and I cited your excellent dissent, Lady Hale, in YL in Birmingham. One of the many examples, I think, of the power of dissenting opinion. And it seems to me that there is a strong view amongst all the people that have given evidence that we need to improve the way in which that works. And so I'm confident we'll get amendments on this. And particularly important because General Comment 16 of the Committee on the Rights of the Child, which relates to state obligations regarding the impact of business on children's rights, emphasizes that states are not exempt from their obligations under the CRC when they outsource or privatize services that impact on the fulfillment of children's rights. And we know that so many of the really important things, so many of the things that cut to the heart of children's rights are privatized, are outsourced, and it's important to note that the state cannot abrogate its responsibilities. Another issue we have is the issue of commencement, which the bill is silent on. But children have waited so long for this that a justification cannot be made for further delay. And so I'm arguing for very swift commencement. These aren't new rights. Public bodies in Scotland know them. They've had reporting obligations under the 2014 Act. And even 6 months or 12 months is a really long time in children's rights. Well, it may not seem it to us. So there's real momentum building in Scotland around this bill. It is a fantastic piece of legislation. It is that bright ray of sunlight in what's been a gloomy year. And it sends a strong message to children and young people. They've been calling on this for decades. And I know that the committee and I also have been hearing from children and young people in their thousands across the country. And they're really celebrating that we've taken this step. But children aren't heard enough. And currently there is a real democratic deficit. Children and young people don't have the same political power as adults. They don't have the same economic power to influence or to lobby. And the systems of redress that we have are difficult to access. And this is another important thing in the bill, that we need to live up to our commitments to child-friendly justice. And it's incumbent upon all of those in power to make special efforts to ensure that children's voices are heard in all decisions that affect them. And this requires change in the way that decisions are made.
Children and young people are not just the future, as we are so often told. We are right here, right now. The decisions that are made today will affect us both today and tomorrow. It is thus crucial that children and young people are at the heart of decision making. This cannot be tokenistic. Our views have to hold weight and be taken seriously. By incorporating the UNCRC, Article 12, the right to be heard, will help this to become a reality. And although we've come a long way in Scotland in terms of recognising children as right holders, we've had a sharp wake-up call as a result of the COVID-19 pandemic. And that cultural change takes time to fully embed, as systems under pressure can easily revert back to their comfort zones. Too many times during the pandemic, we saw a reversion to paternalistic approaches to children and young people, which failed to recognise them as right holders. For example, the exam catastrophe this summer. I doubt that if the Scottish Qualification Authority, the SQA, had taken a rights-based approach, that the lowering of exam rates due to people's postcodes and schools' previous results would have happened. Children weren't recognised as having a stake in the system. Instead, all the decisions were made by and for adults in the interest of the integrity of the system. Well, for me, an exam system that doesn't respect children's rights has no integrity. This so easily could have been different, and that's what makes it so frustrating. Scotland has a world-leading youth-led organisations like the Scottish Youth Parliament and incredible expertise in children's participation that the SQA and Scottish Government could have paid a lot more attention to. I have to declare an interest here. Being a member of the Scottish Youth Parliament has meant that I have been able to feed into national reports, surveys, and meeting with key decision makers. Youth parliaments are a fantastic way for young people to be represented, and especially if, like the Scottish Youth Parliament, members of the Youth Parliament have to consult with their constituencies before sittings and voting on motions, as well as taking part in nationwide consultation to develop our 5-year manifesto. This ensures that we have a mandate that accurately affects the young people of Scotland as a whole, and not just the young people who are MSYPs. The use of having MSYPs who represent specific voluntary organisations, such as LGBTU Scotland or FOSIS, the Federation of Student Islamic Societies, means that specific groups of young people, whose voices are often ignored or not heard, can be heard and represented. However, this is still not enough. Not all decision makers take children and young people seriously, and not every young person can be represented through a youth parliament. All too often, people and organisations view listening to young people as optional or just a tick box exercise, and rarely take their comments on board. This is why examples of best practice must be shared and implemented when it comes to involving children and young people in decision making. There must be alternatives, particularly for seldom heard young people or young people with additional support needs who may struggle to go through formal channels of representation. Their voices and opinions still matter and should be still heard and taken into account. A formal meeting with an MP doesn't work for every child and young person. An alternative must be utilised, such as getting children's opinions through art or through play. We must build on these methods and thus ensure the efficiency and legitimacy of decision-making through children's participation in it. It's important that responsibility to adapt is on adults, not on children and young people. Those in power should be the one asked to step outside their comfort zones. For example, parliamentary processes and the legal system, they should all be willing to flex and change as much as possible to ensure that children's rights are respected and protected. And tradition, or the excuse that we've always done it this way, is no longer an acceptable reason not to change. Outside of formal decision-making structures, children and young people have demonstrated their leadership on a global level through issues such as climate change, food poverty, and exam cancellation. This shows the power of young people. We are not just the leaders of tomorrow, we are the leaders of today. And there is no doubt that the power of the youth is immense. However, there must be support for these young people to be heard by decision makers and hopefully avoid these catastrophes in the first place, such as the exam fiasco, and stop them before they happen. All too often, these young people are brushed aside by decision makers as rowdy youths or people who need to get some life experience and pay some tax. This is simply unacceptable. Young people deserve to be heard and have their rights respected, as we too live in this society, and thus the decisions that are made will affect us too. All too often, I, as a young person myself, feel powerless to influence massive decisions that will ultimately affect my future, such as Brexit and climate change. Since children and young people don't have the right to vote, their voice must be heard through other ways, although as a side note, the voting age must be changed to 16 as it's simply democratic, the fact that it's not that currently. Even throughout the pandemic, we saw this with our Prime Minister urging the public to ask questions, and yet young people who were full of questions about going back to school or exams or just their future were unable to do so because they were under 18. This is simply not acceptable. This must change. Children and young people are not just the future, but we are also here, right now. In the Promote, Protect, Defend report published by Bruce's office, we set out what needs to be done in order to support the incredible work of children human rights defenders here in Scotland. It is clear that a full, direct incorporation of the UNCRC will give children's rights the legal protection they so desperately need and deserve. So today, I am calling on decision makers and campaigners to pledge incorporation to the UNCRC into their country's law in order to make children's rights real. We must all work together towards this goal for the greater good of children and young people. We must all campaign and shout from the rooftops about a full direct incorporation and lobby until this is a reality. It is simply not good enough to say that we agree with that children should have rights. They must be protected under the law and they must be made real. We are seeing that more and more children and young people are becoming human rights defenders and standing up for what they believe in, which is incredible. However, they should be protected by the law. Another thing that must be tackled is the fact that there is currently no fixed commencement date for the bill. We must make children's rights real. We must fix the democratic deficit. We must truly listen to children and young people. And to do this, we must fully and directly incorporate the United Nations Convention on the Rights of the Child into Scots law. We must all promote, defend, and protect children's rights. The time for incorporation is now. Thank you.
Well, thank you both very much indeed. That was extremely informative, very inspiring. And I must say a special thank you to Bruce for the shout out that he gave to my dissent in the case of Weil and Birmingham City Council. Often when one has a dissenting judgment, one just has to take it on the chin, sigh and say, well, I suppose the rest have to be right after all. But that is one dissenting judgment in which I absolutely know that Lord Bingham and I were right. And if that means that changes can be made to the bill before the Scottish Parliament, that is all to the good. So thank you. But thank you for the whole lecture. It was absolutely riveting. And now we're going to have comments from 4 panelists on the subject, not necessarily on the lecture. And I'm going to tell you who each of them is, and then they can go through in turn. The first is Professor Simon Hoffman, who is Professor of Law at Swansea University, where, of course, they have a children's rights observatory, and he played a key role in the development of the Rights of Children and Young Persons Wales measure of 2011, about which you heard in the lecture. He says that he's both a champion and a critic of children's rights protection in Wales. Then there's Anmol Kaur Singh, who is a children's rights activist and has been working with the Children's Rights Alliance for England Change It campaign on homeless families and temporary accommodation for around 5 years. And she's given evidence to the United Nations Committee on the Rights of the Child. Shuxin Liu is a public law practitioner at Doughty Street Chambers, focusing on the rights of children and vulnerable adults. And she regularly advances United Nations Convention on the Rights of the Child-based arguments in domestic child rights litigation. Well, I hope she has more good luck with that than people used to have when they advanced arguments based on the European Convention on Human Rights in litigation in the United Kingdom, or specifically England and Wales, because they usually got short shrift. I hope that she gets much better shrift than that with her arguments. And then Eva Nolan is co-director of the Human Rights Law Centre at the University of Nottingham and co-chair of the Doughty Street Chambers Children's Rights Group, and a member of the Council of Europe European Committee of Social Rights. And she was recently a member of the Scottish Government's working group on the United Nations Convention. So that is 4 very varied perspectives that you're going to hear from. They are asked to speak, each of them, for 4 minutes, and we shall be keeping an eye in the hope that they manage to keep to that. So can I turn over to you, Professor Hoffman, first?
Good afternoon, everyone. Thank you, Lady Hale, for that introduction earlier on. And thank you to Doughty Street for the invitation to be part of this panel. And of course, thank you to Bruce and Becky for your comprehensive, interesting and inspiring talk. I'd like to begin my comments by acknowledging that the Incorporation Bill in Scotland is a hugely significant step forward for children's rights. The approach taken to incorporation in Scotland, and indeed here in Wales, is in contrast to that of the UK government. In this respect, as your talk has highlighted, devolution is a great advantage for children in Wales and indeed in Scotland. I want to make a quick aside here. It seems to me that the Committee on the Rights of the Child has been slow to recognise the potential of devolution to support progress on implementation of the Convention. And in my view, it needs to do far more to encourage leadership from national governments whose commitment to children's rights exceeds that of the state party itself. Of course, Scotland and Wales are examples of leadership on children's rights in the UK. And I'm very pleased that the Convention will be incorporated in Scotland, adopting a maximalist approach. I think with this in mind, there are some insights which may be gained from our experience in Wales since 2011, which is when Wales passed legislation to indirectly incorporate the Convention in Welsh law. I can't possibly cover everything we've learned in Wales, so I'm going to focus on 2 areas. First of all, our legislation seeks to promote a proactive approach to children's rights. This is also, I think, as Bruce mentioned, what is desired in Scotland, and is, I think, a feature of the Incorporation Bill. However, in Wales, there has historically been less emphasis on legal enforcement than there's been in Scotland, with more attention given to how legislation can be used to underpin a culture of recognition of children's rights in ministerial decision-making. And I can confirm that this approach has given greater visibility to children's rights in policy-making, something which I'm confident you can anticipate in Scotland. However, our experience also confirms that measures which seek to mainstream children's rights are vulnerable to a lack of prioritization, which creates a real challenge to fully embed children's rights in the business of government across all departments. And all of this leads me to think that legislation needs to be more prescriptive in order to reduce the discretion given to government to apply procedures which recognize children's rights. And I'm thinking in particular the need for stronger recognition and prescription on child rights impact assessment and on processes for consultation with children. And I make these comments about the position in Wales, but also about the Incorporation Bill in Scotland, which I've read in detail. Another possible insight from Wales concerns court-based enforcement. In the 8 years since our legislation has been in effect, we haven't had a single legal challenge to ministerial decisions affecting children under our child rights measure. A possible reason for this is the form of incorporation we have in Wales, which means children cannot bring an individual claim where their rights are breached, but instead they have to rely on public law challenges to the way ministerial decisions are made. This clearly presents a barrier to enforcement. However, I think one of the main reasons we haven't seen a case come before the courts in Wales is that Wales lacks a culture of enforcement. And as Becky mentioned, there are many hurdles that prevent children accessing justice. In particular in Wales, there is a lack of expert advice and advocacy services which are aimed at children. Of course, the Incorporation Bill in Scotland offers a more direct route to enforcement than we have in Wales. But I think it worth noting that without good coordinated advice and representation services, including a legal profession with expertise in children's rights, there's a real risk that children in Scotland will be unable to take advantage of the legally enforceable rights that will be introduced by the Incorporation Bill, even though the Commissioner has standing to bring proceedings. Okay, there's actually a lot more I could say, but I'm very conscious of time and the time limits. So I think at this point, I'll finish speaking. And so I'm going to pass back to Lady Hale. Thank you.
Thank you very much indeed, Professor Hoffman, and for keeping almost to time. Brilliant. So now, Amal Kaur Singh, please. Can we hear from you?
Hello everyone, and thank you so much for having me. I apologise if I speak fast. I want to stick to the time, but I also have a lot to say. But I'm happy to carry on the conversation off camera if anyone wants to connect on LinkedIn or whatever. But I'll just start by giving a brief background about me. My name's Anmol Kaur. I'm a children's rights activist. I've been campaigning for over 5 years with CRAE, the Children's Rights Alliance of England, on a number of topics within children's rights, and have had the privilege to present our recommendations at the UN in Geneva. I've also recently graduated in law. I did a 5 years integrated master's, LLB and LPC. It was very tough. I experienced a number of personal hardships, but I'm now looking for a training contract, which I've heard is the hardest bit, so I can qualify to be a solicitor so I can help people further. I'm looking forward to be here today to voice my opinions and represent the voices of young people in England. So my response. So like I said, I'm a voice for young people, and I've been campaigning for exactly that, for children's rights to be met and not breached, like they did in my own personal troubles with housing whilst I was growing up. If the CRC was incorporated into domestic law, then issues like this and many more cases in which rights are breached can be taken to court and action can be taken appropriately. It makes it a lot stronger, and it would also mean that when government makes a new law or policy, they would also be considering whether it infringes the CRC or not. As the Children's Act states that the welfare of the child is paramount, the CRC should hold the same amount of importance and dominance in English law. I remember one of the reasons that drew me to campaigning and volunteering with CRAE and to even study law at university was simply because I did not know my rights myself, nor was I taught it in school, even though Article 42 states that we should. And this was something I wanted to change. I believe that with the incorporation, young people will be better equipped for life and hopefully will have to struggle less. There are so many stories of help going wrong, whether that be from police or social workers, but what if we could take the help into our own hands? I'm happy to hear that this is something Scotland are doing. I'm very happy for the young people of Scotland to be experiencing this progression and being able to have power within the law. And I hope that it will alleviate fears, because people in England may fear that there would be loads of court cases, the courts would be clogged up, but we can see how it works in Scotland and we can see how it goes and learn from their experience and show others how well it can work to incorporate it in England. If the CRC was incorporated into domestic law, then I could have challenged my problems in housing. It would have made quite a difference in my life and in children's lives, which is something that they can't do at the minute. It will give them a sense of power and trust in the system. I believe a lot of issues are caused because of the way the current system is. It suppresses the voices of young people, even though that is one of the rights under the CRC, again, to take young people's voices seriously under Article 12. As a result of this, there is often little to no trust within the government and policing, etc., creating further problems and a deterioration in mental health, young people feeling worthless, so on and so forth. Speaking from experience, I can definitely say that I felt like that at a point when I was 14, when my mum and I were struggling in temporary accommodation. We moved over 10 times. We were living out of boxes with terrible living conditions, freezing, no hot meal whilst it was snowing outside. This is something I cannot forget, no matter how hard I try, almost 10 years on. So not only are there cases where children's rights are breached, but imagine the lifelong impact it has had on young people like me and many others, which could be prevented with the incorporations of the CRC in England. Whilst there are still so many issues happening in England, whether that be poverty, housing, immigration, the incorporation of the UNCRC will give us young people our rights back and the power that is supposed to come with it. Thank you.
Thank you very much indeed, Amal. You've been even more disciplined than Professor Hoffman, so well done. Now, can we ask for Xu Liu to join us?
Thank you, Lady Hale. I mean, I wish I could say that I've had a lot of luck in deploying the UNCRC in domestic cases, but really wanted to focus my comments on the limitations of litigating child rights in a context in which there hasn't been domestic incorporation across the board of the UNCRC in any meaningful way. As already mentioned by Bruce and Becky, the government has often said that the UNCRC has already been implemented through legislation in England, such as through the Children Act 1989 and the 2004 Act. But Section 11 of the 2004 Act doesn't really reproduce Article 3.1 of the UNCRC, nor does it mirror provision under Section 55 of the Borders, Citizenship and Immigration Act 2009. What it requires is public authorities listed in the section to have due regard to the need to safeguard and promote welfare of children in the exercise of their functions. And it's very obvious, even from the language itself, why that falls completely short of giving full effect of the substantive content of the obligations under the CRC. It's not applicable in particular to central government decision-making, save in respect of the Home Office. It's a duty, due regard duty about processes rather than outcomes. It doesn't require the children's welfare to be a primary consideration, and provided that public authorities have addressed matters in a manner relevant to the children's welfare, it can be overridden without more by competing interests. The use of the word welfare, in my view, is also a vestige of a more paternalistic approach to protecting children's rights rather than a rights-based approach that the UNCRC advocates. Of course, I'm not suggesting that Section 11 hasn't made a real impact. For example, in Zolomeso and Westminster City Council, the Supreme Court held that the Section 11 duty required housing authorities to have regard to the impact of the child whilst providing temporary accommodation to a homeless family, so that they shouldn't be provided accommodation out of borough, far away from their schools and their support networks. But in the same case, the court observed that where ECHR rights are not engaged, there's a question mark over whether Section 11 itself should be construed consistently with Article 3 of the UNCRC, highlighting therefore the potential limits of Section 11 as a vehicle for implementing the UK's obligations under the UN Convention of the Child. Even where convention rights are concerned, there is no direct read across of the rights under the UNCRC. Rather, the UNCRC has been treated as an interpretive aid, and mostly through Article 8. In that context, Article 3 UNCRC is really as good as it gets at the moment. The remaining provisions of the UNCRC haven't been given effect in UK law, even through the portal of Article 8 of the ECHR. In the context of civil rights, this limited approach has made some headway, for example, to secure entitlement of 17-year-olds to appropriate adults during criminal investigations, to treating child offenders differently to adult offenders when setting sentencing tariffs, and to ensure that the impact on the child is properly considered in the context of enforcement actions such as deportation, extradition, and immigration detention. But it's much less so in matters concerning socio-economic policy, in which the child is not always the direct rights holder, although they are always almost a beneficiary. The law relating to children is too often paved with best intentions without sufficient money, which leads then to nowhere. For example, in JK Burundi, the Court of Appeal took the view that the Secretary of State of the Home Department was not required to treat children's best interests as a starting point when setting asylum support rates, but was entitled to view them as subordinate, even though they are a beneficiary, operating only within the envelope of the limited budget of the Secretary of State. More recently, in a case called Moore and the Secretary of State for Work and Pensions, concerning the way in which universal credit is calculated for mothers in receipt of different maternity benefits, the High Court held that the best interests of the child were satisfied by simply making available universal credit and nothing more. It can't, the best interests of the child can't, in those circumstances, affect the state's choice about the level of universal credit to be awarded to different groups of mothers, even though the method for calculating it resulted in some mothers having 3 to 4 times less in universal credit benefits than others because of the type of benefit they got, significantly impacting on their ability to care for their newborn babies whilst on maternity leave. The Moore case is a real highlight and illustrative of the deficit created by not incorporating substantive rights to Social Security set out very clearly and authoritatively under the UNCRC, and also a failing illustrative of the failing to have child rights impact assessments. So I think we still have a long way to go in England and in the UK as a whole, even though Scotland has taken the best step forward to seeking incorporation, because so much of central government policy related to and impacting child poverty are made at a central level. Thank you very much.
Thank you very much indeed. You mentioned 1 or 2 matters rather close to my own experience and heart. Thank you. And now, finally, can we hear from Professor Eva Nolan?
Absolutely. Thank you very much indeed. And first of all, enormous thanks to Becky and to Bruce for their very thoughtful lecture and for the excellent inputs that I've heard from my fellow panelists so far today. I'm conscious that I'm the last speaker and we have the Q&A ahead of us. So I suppose I just want to offer a few comments from my own perspective as a child rights academic, but also as a child rights advocate and someone who's been involved in processes around the legal incorporation of human rights, whether constitutional or legislative, in various different places across the world and within the UK itself. The key message that I take from today is that we in England, and I say this as someone who's based in England, need to push. And by that I mean we need to push for UK-wide domestic incorporation of the UNCRC. And if we want to do this, what can we learn from Scotland, Wales, and elsewhere? Well, first of all, if we want UK-wide incorporation of the UNCRC to happen, we have to provide clear information on what children's rights are likely to involve in practice in terms of day-to-day decision-making in specific policy areas, from health to planning to overseas development aid, for instance. We need to consider and we need to provide, carefully sifted evidence of what such incorporation would mean in terms of law, policy, and resource decision-making, the day-to-day decision-making that is of key concern to those who would be responsible for giving effect to children's rights should domestic incorporation take place. Domestic incorporation of the UNCRC would be a paradigm shift, and we need to bear in mind that paradigm shifts are very scary, particularly those who are front and center responsible for, implementing that paradigm shift. And fear of the unknown and misplaced but strongly held misconceptions about the additional burdens that will be imposed by domestic incorporation of the UNCRC, which are very prevalent in England amongst law policy and law policy decision makers and administrators. These are very significant obstacles to buy-in from those who need to be convinced if domestic incorporation of the UNCRC is to happen. And there is positively, there is a very large and growing body of comparative experience and practice that we can draw on and learn from in order to address such concerns, not least from Wales, as Simon has made clear. Simon has flagged some of the issues that have arisen in Wales. And in a way, we of course benefit in England from following on from the Welsh experience, because we can build it into our knowledge about the risks inherent in certain forms of approach towards domestic incorporation, and also the challenges that are faced by those responsible for the day-to-day implementation of children's rights. Okay? The second thing that it is crucial for us to do is to prove the added value of child rights. And I found both Anne-Moll and Shushin's inputs here extremely useful in flagging the gaps that have been created in terms of protection of children's rights in England as a result of a lack of domestic incorporation of the UNCRC. And we need, as child rights advocates, to provide concrete evidence, again, based on comparative experience, both within or outside the UK, of how express legal protection of child rights has increased children's enjoyment of those rights in practice. Okay? Again, the Scottish and the Welsh examples are instructive and they'll help us, but there are lots of other countries we can draw on as well too. Norway, Finland, Iceland, which Bruce mentioned, are just some examples. There's lots of examples from the Americas and Africa too. Okay, so crucially, we have to use these to challenge concerns about what child rights mean in practice. We also, turning back, looking at our own system here in England, we need to challenge misunderstandings about the extent to which child rights are currently protected in law, under law, applying in England. And I have been involved in various processes related to the domestic incorporation of human rights. And in all of these, pretty much without fail, I have been repeatedly struck by lawyers with limited human rights, including child rights, knowledge or experience, consistently overestimating the extent to which children's rights are presented within existing domestic frameworks. And this was certainly evident in the Scottish debates, for instance, where you had some participants simply saying, oh, but we don't need this because our system already accords adequate protection to children's rights, something that Bruce, Becky and their colleagues challenged very effectively. It's crucial that we who are pushing for domestic incorporation of the UNCRC would make it clear what rights entail, both in terms of content and crucially in terms of the duties that they impose. Okay? We will not have domestic incorporation if there isn't a strong sense on the part of policymakers and lawmakers that they have an idea of what they will be getting as a result of such domestic incorporation. I want to make one final point, and this is a major challenge in a country, a nation where media, political and societal talk of human rights and child rights is predominantly focused on the courts. And we need to challenge and change the predominant discourse on child rights. We need to focus on presenting child rights as tools that support good governance, not as beating sticks for hard-working or cash-strapped public authorities or other duty bearers, which is often how they're presented in the media, for instance. Children's rights' greatest value is as a proactive framework for law, policy, and budget making. Becky, as Becky raised the exams fiasco, would that have even arisen if children's right to be heard had been given proper effect to and children's views built into from the very beginning around the issue of exams during COVID? It is very hard for anyone to argue convincingly against the domestic incorporation of the UNCRC, where this can be demonstrated as supportive of good faith democratic governance with positive outcomes for people in society, not as something that undermines or is antagonistic to it. Thank you.
Thank you very much indeed, Professor Nolan. And now we're going to turn over to Keithan Gallagher, QC, who is going to mastermind the Q&A session.
Thank you very much, Lady Hale. And huge thanks to everyone for their contributions, and to Bruce and Becky for such a powerful lecture. I'm going to start with a comment which we've been asked to put by Ross Matthews from the Equality and Human Rights Commission. And this is a comment rather than a question. He said he's joined us today representing the Equality and Human Rights Commission, and he wanted to share that the Commission's latest report to the UNCRC will be published tomorrow. And he noted that it makes recommendations which reflect many of the issues that have been covered by Bruce and Becky in their lecture so far, and by Lady Hale in her opening remarks. So that's one to watch. Can I start with a very technical, quick question for Eva Nolan, please? We've a question, Eva, from Neil Fairbrother, who's asked, what's the difference between the UK's ratification of the UN Convention on the Rights of the Child and bringing it into UK national law? And bearing in mind that in our audience, we've got a combination of lawyers, activists, academics, young people, and so on. Could you give an answer to that question, Eva, please?
Absolutely. So when the UK ratifies an international treaty, it volunteers to be bound by it. And when it ratifies, this gives rise to obligations on the UK under international law. And the enforcement mechanism and the monitoring and the accountability system are really the concern of international law. If we're talking about domestic incorporation, there's lots of different ways it can be done. But possibly the easiest way of explaining is that we're talking about, we're talking about bringing international standards into our domestic law so that they form part of our domestic law and create obligations in terms of domestic law, not just international law. That is a terribly simplistic question to a very terribly simplistic answer to a very important question, but I hope that that's helpful.
That's great, Eva. Thank you very much. And I've got a question for everyone, which comes from Professor Andrew Rowland. So Professor Rowland has said, it's fantastic that Scotland led the way in giving equal protection to children in effectively prohibiting their physical punishment, promoting their Article 19 UNCRC rights to be protected from violence. And Wales will also do the same, which is fantastic. What advice would you give to professionals with an interest in protecting children's rights about what role they can play in achieving the same protection for children in England and Northern Ireland? Many of you in the audience will have seen some of the coverage in the last number of weeks about smacking being banned in Scotland. That's what this question refers to. So Professor Rowland's question on what tips you can give to people wanting to campaign on that issue in England and Northern Ireland. Could I start perhaps with Bruce and Becky, if you have any answers to that question?
Absolutely. We're so pleased that that law came into effect just a couple of weeks ago on the 7th, and that was timed, there was commencement on the face of the bill. So it was a year ago that the Scottish Parliament passed that in royal assent, and then it came into effect on the 7th. What's interesting about it is it was it was a Green Member of Parliament who brought that forward. It wasn't a government proposal, and in fact the government opposed it initially, and it was only when it became apparent that there was public support for it that the government changed its position. It was a very simple piece of legislation which removed the anomaly in law that allows for parents to assault their children for the purpose of physical punishment and to have that justified. Totally against international human rights law and against the values that we hold. Some of the strong arguments that we made early on, the legal arguments, were pointing out that there had been a number of cases to the European Court of Human Rights historically, where the UK, unfortunately, has a lot of the leading judgment on exactly this issue about banning physical punishment in schools and in private schools and the use of an implement. And each time the government has taken the narrowest interpretation of the principles that underlie it. And so how we approached it is that we built public opinion around it. My office worked with civil society and commissioned some really fantastic research that looked at the experience of other countries. We got particularly kind of medical professionals on board. We got faith groups on board. We got the police on board. And parents groups were really strong in this as well.
This is like a campaigning 101, Bruce, on it. This is amazing.
Yeah, and it was exactly that. And then particularly we approached a Green Member of Parliament who is a former police officer who had physically chastised his own children, and so had huge credibility in a way that I wouldn't in speaking to people. And what was really interesting is that when this was discussed in 2003, sorry, I'm aware of time, when this was discussed in 2003 and the law was last done, the media was awful around it. It was an awful experience for all involved, where they were discussing in Parliament the size of the implement you could use to assault a child or not. This time around, there was very little public opposition. Yep. There was one campaigning group that had almost no support. So it's an idea whose time has come, I think, is my point.
I think what this discussion has shown us is that actually we should be having a separate seminar on corporal punishment and children's rights, because that's fascinating what you've said, Bruce. Becky, did you have anything to add on campaigning tips for people in England and Northern Ireland who may wish to take this issue forward?
No, I think Bruce has covered most of it, but a lot of the children's charities in Scotland, like Together and Children in Scotland, as well as Youth Parliament, did a lot of campaigning on this. Thanks
so much. And I think just I do want to bring in Louise King from CRAE, from the Children's Rights Alliance for England. So Louise has not given a presentation, but as part of our panel. And could I ask you, Louise, a more general question about campaigning as a child rights advocate? And what key obstacles to the realisation of child rights in England do you see in your work?
Thank you, Keelan. Well, I think one of the sort of the key obstacles is really how far down the political agenda children are at the moment, and have been for some time. And I think it's kind of a bit of a sort of a catch-22 situation. One of the reasons we are nowhere near getting CRC incorporation by the UK government is simply for that reason. And because of that reason, because it's not incorporated, it just leads to children being completely invisible in decision making. And we've really seen that through the pandemic in terms of some of the regulations that have been passed with very limited parliamentary scrutiny, and also because we don't have any statutory obligations in England to carry out child rights impact assessments. Actually no scrutiny in terms of the impact of those regulations on children and their rights. So just to give a couple of examples, we had the social care regulations passed, which took away 65 protections to children. We've also had regulations which have a really detrimental impact to children in prison. So they're locked up in their cells for most of the time, only allowed out for just 1.5 hours out of a 24-hour period. We've recently had the remand regulations passed, which extends the length of time that people can be remanded to prison. And of course, that impacts on children. So I think that's a real key problem, that there's this lack of scrutiny of children's rights as part of government policy and decision making, and we see that constantly. So for example, I know Shushu Lu talked earlier about welfare reform and what a detrimental impact that had in terms of child poverty. Child poverty is increasing, as we all know. We've got 4.2 million children living in poverty in the UK at the moment. And that has really been impacted from that welfare reform in terms of the 2-child limit and the benefit cap. Again, so little scrutiny of children's rights as part of that decision making. And also in relation to kind of violence against children, for example. I'm sure people are aware that the police can use taser on children and spit hoods. It's abhorrent that that can even be allowed to happen. But even more shocking is the fact that the police don't have any specific guidance or training on their use on children. So it's that invisibility of children, which I think is really key. And that's why we'd really want to have incorporation, because as well as the redress, which is really, really crucial, it would also have a really, really important part to play in terms of making children central part of government decision making, and really making sure they are high up on the political agenda.
And actually, Louise, that fits in very well with one of the questions that we got from an anonymous attendee asking about the limitations to litigation, and saying, you know, how best can we address children's rights failures when in some respects you already have mechanisms through the Human Rights Act, the Equality Act, but you need to look at matters short of litigation. You need to look at litigation plus and steps you can take pre-litigation. I think that fits in very well with what you've just said. You've also mentioned the benefit cap, and bearing in mind the very powerful comments that Bruce made about Lady Hale's dissent in the YL case. And for those of you who haven't read it, please do. And bearing in mind Ruth Bader Ginsburg's comment describing dissents as speaking to a future age, it being not simply to say my colleagues are wrong and I would do it this way, but the greatest dissents do become, she said, court opinions, and gradually over time their views become the dominant view. So that's the dissenters' hope, that they're writing not for today but for tomorrow. Could I ask all the panel if there's any particular dissents on child rights issues which they think may indeed be written for tomorrow? I mean, I have in mind some of Lady Hale's dissents, but also Lord Kerr's dissent, for example, in SG in the benefit cap case. And I'd be interested to hear others' views. Could I start with you, Aoife, on that question?
I'm afraid I'm going to sit around it, but I think I'm going to give you an answer as someone whose work has not solely or even primarily focused on the UK historically. I work primarily in the area of children's economic and social rights, and it has been stunning to watch, as we've seen economic and social rights come centre stage, the way in which indeed dissents in a wide range of different jurisdictions have been used as kind of the shall we say, the footpaths and the footsteps that are subsequently followed by more progressive subsequent courts. So I don't have a particular one, but I would absolutely agree that that's how it operates. And it has certainly operated that way internationally in the context of children's economic and social rights particularly.
Thank you. I'm sorry for my very nerdy question. What's your favourite dissent? But what about Simon? Do you have any comment on a particular dissent on child rights issues, which you think may be a blueprint for the future?
No, once again, like Aoife, I'm going to sort of skirt around the issue. I agree that the dissent in the SJ case was really powerful, and it's something that I use all the time with my students on my Human Rights for Children course. And like Aoife, I think that dissenting judgments are a signal to what's coming down the road very often, and we need to keep a very close eye on them. So I don't have a particular favourite. But I'm very conscious that something I say to my students and something I say to myself, always read the dissenting judgment.
Absolutely. Shushin, having received quite a few dissents on child rights issues, I suspect you will have a favourite like me.
Oh, wow. I don't know if I'm as nerdy as you are on this, Caitlin, but could I also sort of try to skirt around? I mean, I think SG is probably the one that in recent times is the most memorable one, because it gave a significant steer for the second benefits cap challenge. But I've been thinking a lot in preparation for this talk, and also in preparation generally on other ways of advancing child rights, is whether or not sometimes when you look back at judgments, even the adverse ones, if they were to be rewritten as child's rights focused judgments, what would be the outcome? Similar to sort of the women's rights project and looking at the judicial project of looking at judgments in a women's rights perspective, how would the outcome be different? And I wonder whether or not, if we have a better understanding of substantive rather than best interest, substantive rights under the CRC, we would be approaching particularly challenges to do with the welfare reform and the Secretary of State for Work and Pensions policies, whether we would be doing that slightly differently, and whether or not the courts would look at it differently as well.
Thank you, Shushin. I'm very conscious of time, and we've got some really fascinating questions. Can I just flag, for those of you particularly interested in the Wales dimension, in the Q&A part rather than the chat function, there are some comments from Theo Huckle from Doughty Street Chambers, former General Counsel in Wales, on some specific Welsh aspects. And I'd urge those of you particularly interested in that to take a look at Theo's comments. He takes issue with Simon's view that Wales lacks a culture of enforcement. And he says, and I quote, as Counsel General, I often resisted ministers' attempts to enact further law, much of it enforceable by criminal penalties. You can see his detail there. Could I put a question, Bruce and Becky, to you specifically, and you may have a view on this as well, Simon, about devolution, about whether devolution has been good for children's rights? And could I ask you to keep your comments short in response?
Yes, I think it's been very good for children's rights. I only arrived in Scotland after devolution, so I didn't experiencing it before, but certainly what we've seen is particularly the way in which the Scottish Parliament works and the strength of that as a legislature, and their focus on being a human rights guarantor is something very, very different. It's work that the Parliament has done, and decisions can be made very quickly. And so I think devolution has really helped in terms of having a legislature which sees itself as a human rights guarantor as a whole, rather than perhaps seeing it as a specialism within the legislature. I think that's something that's quite exciting and new.
Yeah. Becky?
Yeah, I think also with the Scottish Parliament, there are like 8 representatives for each person. So it's a lot easier for children and young people to like contact their representatives. But also like if the UK did decide to implement the UNCRC, like we wouldn't have to, devolution wouldn't have had to be so important if the UK had decided to do it first.
Great. And Simon, any comment from you on that?
Yeah, I think devolution has been fantastic for children's rights in Wales. From the outset, the Welsh institutions, governmental institutions, committed themselves to the UNCRC as the basis for policy and legislation in Wales. And we've seen that commitment followed through, not just with the child rights measure, but other legislation, including legislation on social services and on education and special educational needs. So I think it's been a fantastic opportunity for children's rights, and some research that I did recently with Children in Wales, the umbrella NGO, certainly confirmed that the child rights measure, for example, has had a great benefit for policy making and advocacy for children in Wales. So yes, a strong dividend of devolution.
Thank you so much. I'm sorry to those of you who had questions which haven't been answered. To the person who's asked the question about criminalisation of child victims, if you message me separately, I can provide you with some further detail on underuse of Section 45 of the Modern Slavery Act and some related issues which have arisen at ICSA, the Child Sex Abuse Inquiry. And just finally, there have been a number of questions about COVID and children's rights, and I'm particularly interested in those of you who we haven't heard very much from in the chat, and whether you have any closing, very brief remarks about the impact of COVID, the coronavirus pandemic, on children's rights. Could I ask you first, Anmol, on that question? And could you keep it to under a minute so we can hand back to Lady Hale?
Sorry, could you just repeat that? My connection just went.
Of course, sorry, Anmol. I was just asking if you have any thoughts on how coronavirus, the COVID-19 pandemic, has impacted on children's rights. Any closing thoughts on that issue?
Yeah, definitely. I believe that there hasn't been much support, unfortunately, speaking from experience in London, not so much support, whether that be financially. There's been a lot of organisations offering support, but I think probably for young people in care or people that are in system, or if I was still in temporary accommodation, it would be very, very different. So obviously because of the having to keep distance and all the rules. So yeah, I believe it's had quite an impact.
Thank you. And I'm afraid we're out of time on the Q&A, and I'll hand back to Lady Hale. Thank you.
Well, thank you, Kieran, and thank you for all those interesting questions. I've taken 4 broad messages away from this afternoon's wonderful event. The first thing is that children's rights are not the same as children's welfare. Children's rights look upon children as agents, not the mere recipients of other people's concern for them. Secondly, a duty to have due regard to the Convention rights is better than nothing, as the Welsh experience definitely shows, but it is nothing like as good as full incorporation, as my experience with the 2 benefit cap cases clearly shows. And a third thing is that the greater concern for children and young people's rights is good not only for them, but also for all of us grown-ups as well, because our children are our future as well as their own future. And then finally, what a lot we can learn from both Scotland and Wales. So thank you to everyone.
At the moment, so please leave your message after the tone.
So thank you all, everybody, very much indeed. And thank you to Kieran and Ufa for organising this wonderful event. It's been terrific.
And may I at this point just intervene very quickly towards the end of what has been a very exciting and thought-provoking and extremely rich event, in order to say, first of all, enormous thanks to our fantastic lecturers this evening, Bruce and Becky. On behalf of Doughty Street Chambers, it was fantastic to get to host you. Thank you so much, Lady Hale, for your superb chairing of today's event. It has been wonderful to have you involved and to have your insights and your superb synthesis there, I think really captured the core of the discussions today. Thank you so much to Simon, to Anmol, to Shushin, to Louise, for your inputs as panelists, which greatly added to the discussion that we've had both amongst the panelists and participants in the Q&A, but also in the public chat, which it has been a pleasure to read. I want to finally say huge thanks, well, second from last, say huge thanks to those at Doughty Street who supported this event, to Ray, to Richard, to Sian, very, very many thanks indeed. It would not have been possible without you, and to Keelan, my co-organizer, of course. But finally, I want to thank you, the audience, for turning up. We have heard so many times that it is a grim and a strange time. It is wonderful that today we have had 90 minutes together in which we've been able to focus on such a pressing issue, hearing the good news stories, talking about advocacy, talking about pushing ahead to try to secure for children and for society in general a better, more just situation than the one we're currently experiencing, and which COVID has so greatly revealed and exacerbated. So may I ask you to join me in that slightly strange Zoom way and clap or raise hands. But thank you all so much and have a good evening.